Well, it appears, Mr. Karras, that you are just going to be alone this morning, present your argument to the court. So you will have 15 minutes, and this time you don't have to reserve any time for rebuttal since there's no one else here. Obviously, you know the rules. We are going to be recording, so you need to stand behind the podium and keep your voice up, and obviously introduce yourself and the party you're representing. And then please do not mention the name of any victims or any children, any minors. You can refer to them just as a child or by their initials. I personally prefer child because it's hard sometimes to keep track of all the initials, but whatever is better for you. All right, we're ready to proceed.
Thank you, Your Honor. To the panel, may it please the court, Andrew Karras on behalf of appellant father Brian Klauser, father to the 2 minor children involved in this case. The statutory basis on which the trial court rested its prong 1 finding of the permanent custody test, that is, that the children could not be returned within a reasonable time to the parents or should not be, asks the court to look to, quoting the statute, the conditions causing the children to be placed outside the child's home. That's revised code 2151.414E1. But here the trial court based its prong 1 finding on parental problems other than the ones that at least acutely caused removal. And for that reason, we would ask that this court find that prong 1 finding not supported by the record. Principally in our brief, we rely on 2 of this court's previous cases, QC and AT, which both hold in different ways that pre-complaint conduct can't bear upon an E1 finding. Now, in this case, we're making, I think, a point that is corollary to, that flows naturally from those decisions, which is the statute implies that there are 2 kind of temporal periods you're looking at when the trial court is relying, again, on E1 specifically as its statutory basis that the children can't be returned within a reasonable time or should not be, which is you look at the time of removal, the circumstances surrounding removal of the children from the home, and then the parent's case plan progress as it relates to the issues that caused removal. Now, here, the trial court based its prong 1 finding on problems to wit, failed drug tests, substance use history, as well as father's subsequent criminal history, when those aren't, precisely speaking, what caused the children to be removed from the home. Now, the dependency issue.
Counsel, what is Children's Services Board to do? So Children's Services Board to do then when you have a situation where a urgent matter removes the children from the home, a juvenile World 6, where there's nobody else, let's say, and to take care of the children, and then they later on, after they file their complaint, learn other things. Do they have to amend their complaint in order to raise these other issues and make it part of the case plan and the reason for removal? Because technically it wasn't the actual reason to begin with, but significant facts may be brought out as they're investigating that would clearly prevent these children from being, I'm not saying these kids, but these children in general from being returned to a home.
Certainly. So I think the agency can do one of 2 things, which is could, under appropriate circumstances, amend the complaint to include conditions that give rise to dependency that, then give rise to case plan requirements. Alternatively, it can rely on any of the other 15 enumerated statutory bases in revised code 2151.414 subsection E, or indeed any other factor, right? So the statutory scheme of that the statute sets up says the court, permissively can determine based on all available evidence whether the children can be returned within a reasonable time or should not be, and then must find that if one of the enumerated 16 factors are present. So here, as a matter of the exclusive basis the agency advanced in its closing argument was E1. That was the exclusive basis the trial court relied on in issuing its permanent custody decision. So that is not to say that in other cases where post-complaint, post-removal, certain facts are discovered that They couldn't rely on any one of those other statutory bases, and indeed some which may have some bearing on this case, but nevertheless which did not drive the trial court's decision. And I would just emphasize that this court has held in a number of its previous cases that where the trial court's decision, the trial court's decision is reviewed for the precise statutory basis at prong one that it chooses. It's not appropriate for a reviewing court in the first instance to infer some alternative statutory basis. So for instance, even where it's apparent from the record that this trial court exclusively relies on E1, but say it's also a 12 and 22 case, where the trial court doesn't specifically find in its permanent custody order that it is a 12 and 22 case, that warrants reversing that prong one finding.
And it would just be sent back for additional findings.
Depending on the circumstances of the case. Now here, I don't know which specific statutory basis other than E1 the trial court might rely on, whether that be repeat criminal history. I mean, the 7 to 11 factors that enumerated specific statutory offenses I don't think apply here. And I think it may be something for the parties to decide amongst themselves whether further evidentiary hearings are needed, because again, the state made the strategic decision to exclusively proceed with an E1 theory as the prong one. Okay, so unless there are further questions about, again, the sort of first half of our first two assignments of error, I would rest on the basis of my brief. Just a brief point on the second half of those assignments of error, which is the best interest analysis. We've laid out a seriatim argument, a factor by factor analysis that I think demonstrates each of those factors faithfully applied, militates against permanently terminating mother and father's parental rights in this case. It is true that the trial court did, in this case, journalize at least each of the enumerated statutory factors, and the cases say that it doesn't have to do that, but it does need to, at minimum, consider those factors and reflect, just submit that for the reasons articulated in our brief, each of the statutory factors militate against permanent custody here. And finally, just a brief point, not on the merits of our third assignment of error, but the third assignment of error related to intensive efforts to find kinship caregiver resources. The state has suggested that the failure to raise it below relegates this to plain error analysis. I would just say that the record is the attorney for the children solicited an answer about what efforts were made to find kinship resources. In closing arguments, all parties, at least in general terms, opposed granting permanent custody. They all requested 6 months extensions and joined in their motions together. And I would say that that's sufficient to preserve the issue for this court's analysis.
Counsel, I want to double check. Father, did he file a motion for a 6-month extension as well? Or just mother?
So just mother, and then in closing argument, father joined it. And I believe he did in his opening statement.
Because father, at this point, is not even arguing that he's in a position to take the children.
That is correct.
Okay. Another question in regard to best interests. I am recollecting, after reading these briefs, I can't remember, there's a lot of information about the condition for the mental health, the behavior, so forth of the children at this point. I know they're teenagers. Was there evidence presented about the behavior or the mental health or the circumstances of the children before the removal and after the removal?
No. The focus of the evidence tendered as it relates to mental health and counseling history were on the parents, and more specifically than on the substance of that therapy, on the parents' attendance records at those sessions.
So we don't have any evidence that, like in most of the cases we have, where somebody is, fearful, or they're missing school, or, there's all kind of behavior issues, and then once they get into foster care, those dissipate. So it's not something like that in the record.
I don't think the record squarely demonstrates that.
Thank you.
And unless there are further questions, I appreciate it, and I do have some time left for argument. I would just rest in grace.
Anybody have any more? No, thank you. Okay.
Thank you.
Thank you much for showing up and arguing to us today. And we'll take the matter under advisement and send a written decision to both parties and put it on the Supreme Court website too.
Thank you.